Welcome to today's Chamber Live, a COVID secure workplace looking at HR and health and safety guidance. Presented for us today by Oliver McCann, who's employment partner, and Chris Walker, who's the head of health and safety at Napthens. The views expressed in this seminar don't necessarily represent the views of the East Lancashire Chamber of Commerce, but they probably do. But all facts are believed to be correct at the time of recording, which is the 22nd of July, 2020. Let's meet our guest speakers then. Chris Walker heads up the health and safety team at Napthens, providing health and safety advice, guidance and training to a diverse multi-sector portfolio of Napthens health and safety clients across the north of England. He works with clients to develop and implement their health and safety policy, also wider health and safety management systems, including completion of risk assessments, site audits and inspections, incident and accident investigations, and provision of specialist technical support and information. Ollie McCann is an employment law and HR partner, and is also head of Napthens Blackburn and East Lancashire office. He's highly experienced in employment law and HR issues, with astute commercial awareness and a determination to achieve his clients' objectives and to deliver solutions, which makes him a valuable business advisor. He acts for businesses of all sizes across all sectors, from small owner-managed businesses through to large PLCs, education establishments and charities. And as I mentioned earlier, he holds the record of the most viewed Chamber Live webinar, both live, but also for the post views on YouTube. Although, to be honest, we're not sure how many of the YouTube views are of him watching himself. We'll let him defend himself in a moment. Time to hand over then, Oliver, and I think Chris going first. Over to you, gents.
That's great, Simon. Thank you for the introduction. I can confirm that at least 90% of those views will have been Ollie. But yeah, that's just my opinion, of course. So yeah, thanks for the intro, and good morning, everybody. Thanks for joining us for the session, where first up, me, Chris Walker, head of health and safety at Napthens, is going to talk you through the health and safety considerations with regard to operating your workplace in the times of COVID, and how to make your workplace COVID secure. Some of the issues to look out for in doing so. So we're going to have a little look this morning at health and safety law, and what is required of an employer's responsibilities in normal times, and how these apply to coronavirus, to COVID-19 specifically. We'll have a look at the specific actions that must be taken in all your workplaces, and the workplace arrangements which might need to be amended or implemented in accordance with the government guidance. While I'm doing all of that, and before I hand over to Ollie, I'll be doing my very best to not say unprecedented times, because I'm sick of the phrase, to be honest. I want to see if it is possible for me to not say it again for the rest of the session. And also because I think we should start to look at the positives, the green shoots of recovery, to use a well-used phrase. Our workplaces and preparing them for a return to work or for COVID security is a really, really important step. It's a challenging one, but it is one that we should be approaching positively. Let's take our businesses into the post-C word world, out of the shadow of COVID-19, and make our workplaces COVID secure so we can get back to business as usual as quickly as possible. So I'll share my screen now. If this is where it all goes wrong, then I apologise. Just get some slides up on the screen. Great stuff. I'm always worried that might be a holiday photo or something similar to that, but glad to see it is the slides. So preparing a COVID secure workplace and the health and safety considerations. Now, Simon's already given a superb introduction to me, so I won't go over all of that again. But just give you a quick overview of the Napthens Health and Safety Service. As Simon said, we do deliver a wide range of health and safety services to clients across a number of sectors. We partner consultants with specialist experience or interest in those areas with customers who need support in meeting their health and safety obligations. As Simon mentioned, my own interests and experience are in occupational health, health surveillance, waste management and facilities management sectors. I've been with Napthens Health and Safety now for 15 months. And I lead a team of health and safety consultants in their delivery of the range of health and safety services. Key to our offering really is building the tailored, client-focused health and safety solution, and trying to be as innovative as we possibly can in terms of making health and safety solutions work for business, not just be an obstruction to it, which is unfortunately the perception of health and safety in the workplace is often one of an obstruction to meeting the business's objectives rather than a means of facilitating it safely and effectively. So the focus of our solutions is to make sure that we partner with business to help them deliver their objectives while keeping health and safety in mind. The world doesn't revolve around health and safety 100% of the time, but it is an important part, should be integral to all of your business planning and operations. Down the right-hand side of the screen, as I look at it, there's a graphic that sums up the past 17 weeks of my life and the life of many health and safety practitioners and consultants. We've been focusing our support throughout the COVID-19 crisis on initially that first phase of helping organisations adapt and adjust to home working in a safe and compliant manner, to support those organisations that needed to continue working those essential services, making sure that they did so as safely as was practicable during that period, and then helping in this final phase the organisations who have not yet returned to normal operations to start to plan and implement the measures that they need to do so safely. So the session will focus this morning on a little bit of background. I won't go to town on background on COVID-19, and I won't take you all the way back to China in November 2019 or any sort of history lesson. But we'll just give a little bit of a background in terms of where the advice and guidance has come from in terms of what are the impacts on workplaces, what has led us to the position that we are in now from a legal standpoint and also from a guidance standpoint. I'll talk you through an overview of a risk assessment approach, how to approach risk assessing COVID-19 in the workplace. We'll look at the COVID Secure Workplace guidance. You should all be aware that there are a significant number of sector-specific guidance documents. But if you've read any more than one of those sector-specific guidance documents, you'll notice that around about 80 to 90% of the content is pretty much mirrored throughout the range of documents. And it's those core principles of COVID Secure Workplace that we'll work through as part of the session this morning. We'll look at some of the often forgotten consequences of being COVID secure. I wrote a short article for a website a couple of weeks back that was entitled "Hand Sanitizer Won't Stop You Falling Off a Ladder," and just the purpose of that being really to remind organisations that a COVID secure workplace is not necessarily a safe workplace, and it's not necessarily legally compliant from a health and safety perspective. Don't compromise existing health and safety measures and introduce additional risk by managing and mitigating the risk of COVID-19. I think there's a lot of work to do in terms of looking at our organisations from a health and safety perspective. Making them safe while they are COVID secure is very much the next phase of where I see me spending a lot of time giving advice. We'll look at the additional health and safety considerations before we hand on to Ollie to discuss the employment law considerations. And one of the things that will be thrown up certainly through the health and safety aspects of the session are the potential employment law consequences of doing the things that I tell you are essential and doing the things that I tell you are essential not to do, which Ollie will pick up in his own expert way when we get to that section. And at the end of the session, there'll be some time for questions and answers, or certainly questions. Whether or not answers will be forthcoming remains to be seen. Okay, so to give a bit of background first up, then the UK coronavirus response will take you back to where the key decisions and the key changes struck us and affected us in relation to our businesses and management of COVID-19. As I say, we won't go right the way back to the beginning and discuss who did what, where, when, how it originated. What we do know, as a matter of fact, is that on the 26th of March 2020, the Health Protection Coronavirus Restrictions England regulations came into force, and it is these that have had the most significant impact on the operation of our businesses right at the very beginning of what I will call, for the purposes of this slide, the full lockdown, when the maximum restrictions were brought into play. So on the 26th of March 2020, these restrictions were cast into law, and they required a number of very specific acts. They required closure of certain types of businesses and premises. They invoked restrictions on movement, stating that no person may leave the place where they are living without a reasonable excuse. And those reasonable excuses included travelling for the purposes of work, where it is not reasonably possible for that person to work from the place where they are living. And that took us right into phase one of the graphic on the preceding slide, which was that adapting to working from home. Now, a number of weeks ago, the government changed the message from the graphics that you'll recognise on the right-hand side of the screen, from the stay at home, protect the NHS and save lives message, to the stay alert, control the virus and save lives message. Now, the key differentiators from a workplace health and safety point of view are that right at the very beginning, when these restrictions, regulations came into place, there was a clear guide and instruction to individuals to stay at home. So in order to conduct your business operations, there was very much a force that was prescribing you to actually invoke home working where it was possible to do so. However, right from the very beginning, there are a number of organisations that could not work from home. And for various reasons, those conducting process, manufacturing, construction, right at the very beginning, despite the coronavirus restrictions, were able to continue operation, but did need to take into account certain coronavirus restrictions and measures within their workplaces. There are a number of subsequent amendments and revocations to those original coronavirus restrictions regulations. I was just having a sum up this morning at the number of changes that have happened in such a significantly a short period of time. Version 2 came into effect on the 3rd of July, revoking the majority of version 1 and leaving us with restrictions on gatherings of more than 30 persons, powers to restrict access and close certain public spaces. And then a quick flick through version 3 this morning, which came into effect on the 18th of July and brought into force the local authority powers to act and respond to outbreaks regionally and on a local level. What is probably the most surprising thing that I learned this morning, in counting back through my calendar, is that the 26th of March is 17 weeks tomorrow, which has absolutely flown by. With the majority of those original restrictions having been revoked, we're now in the position of moving beyond the full lockdown and following all the changes to applicable coronavirus law and guidance. What are we as employers required to do now? So what must we do in the absence of these clear instructions? And perhaps the best place to start in looking at where we, or what it is that we are required to do now, is to look back at what we're always required to do as employers. And while this certainly won't be a 45-minute lecture on the Health and Safety at Work Act, albeit I would love to do that, the key employers' responsibilities that are of relevance here are outlined in the Health and Safety at Work Act 1974, where your duty as an employer is to ensure, so far as you reasonably practicably can, the health, safety and welfare of all of your employees and the others that are affected by the things that you do in the workplace. So Health and Safety at Work Act, keep people safe, don't harm anyone as a result of your undertaking or the carrying out of your business. And you need to do that as far as you reasonably practicably can. The management of health and safety at work regulations require organisations to make a suitable and sufficient assessment of the risks to the health and safety of employees to which they are exposed at work. So these regulations, as well as a number of other things, require you to avoid risks, evaluate those that cannot be avoided, and control them. So as per the COVID-19 outbreak and application of the Health and Safety at Work Act and management of health and safety at work regulations, is there relevance? COVID-19 is not a workplace hazard in the traditional sense. It doesn't arise out of the work activities. But I'll just give you some background from the Health and Safety Executive in terms of their interpretation of the Health and Safety at Work Act and the management regulations to help you understand your responsibilities as employers with regard to COVID-19 specifically. So as per the applicable regulations, employers are held to be responsible for reducing the risk of harm to their employees and others who use their workplace or might be affected by the activities that they carry out, only from reasonably foreseeable hazards. If a hazard is reasonably foreseeable, you are expected and responsible for reducing the risk of harm from that hazard. The risks that a business is required to manage, having identified them, are only those which employers, as duty holders, can actually exercise control over or mitigate the consequences of through the way that they operate. And specifically from the Health and Safety Executive, this includes risks which arise from external circumstances over which you as the employer have no control, but whose consequences you can mitigate through the conduct of your business. So COVID-19 transmission is certainly reasonably foreseeable, and on the basis that transmission is reasonably foreseeable in the workplace, we are responsible for identifying that hazard and managing it. The risk arises from an external circumstance, of course, but you can mitigate the consequences of that risk and minimize the number of individuals exposed to it through the operation of your business by arranging yourselves in a responsible way. And that's where the government guidance on COVID secure workplaces comes in. When you're managing risks from identified hazards within the workplace that you are responsible for, you're required to do so as far as is reasonably practicable. So there is a balance between the reduction in risk to which employees and others face in your workplace and the cost, time, and effort associated with implementing the control measures that are required. So there is a judgment and a business case to be built for the implementation of certain control measures where the risk needs to be managed, how effectively it will be managed, but the cost and effect on the business of doing so. So there needs to be a balance drawn between the two. So in terms of making sure that we are COVID secure and compliant with the law from the COVID-19 perspective and managing our health and safety responsibilities, we must ensure that we have carried out a risk assessment. And the risk assessment approach here, I won't talk through in vast detail now, as there's quite a lot in it, but the simple principle of the COVID-19 risk assessment is to continually reevaluate the threat that COVID-19 poses in your workplace, to look at whether or not you are currently a business which is in a sector permitted to operate by law, and then to work through an effective hierarchy of controlling the risk within your workplace. So by evaluating the latest government guidance, looking at the legal prohibitions on operation of certain types of workplaces, coming to the point where you can conduct a risk assessment of your activities. And we'll talk a little bit more about the specifics of what goes into a COVID-19 risk assessment on some of the subsequent slides. But the broad principle of the flow chart in front of you goes through the hierarchy of control, where the most effective controls will be reached nearer the top of the flow chart, and the least effective controls at the bottom. So in the very first instance, the fewer people you have within a workplace where it's reasonably practicable for you to not have them there, the less risk of active transmission there is, which is why the drive for home working was so significant right at the very beginning. Now, government guidance remains as it stands today that if it is safe and your employees can effectively work from home, then they should continue to do so to reduce the risk of transmission within your workplace and to reduce the amount of contacts that they have. Now, the majority of workplaces will have certain roles that cannot be fulfilled from home, and certain sectors will have no roles at all that can be fulfilled from home. And in those cases, risk assessment is required of the specific tasks and activities in the workplace to determine the control measures that are required. Now, effectively, the control strategy, as prescribed by the government guidance documents, is focused around hygiene, maintenance of social distancing, and the removal or non-admittance of those that are symptomatic or tested positive for coronavirus within the workplace. So it's important that at this stage, if it is safe to work from home, employees are doing so. If it's not possible, or they can't effectively fulfill their duties from home and they are within the workplace, have you conducted a risk assessment to determine the areas they may be subject to potential transmission, and have you implemented effective control measures? Obviously, the flow chart doesn't come to an end with conducting your risk assessment. Continual review, much like the risk assessment for any other hazard within the workplace, is required. Continually checking the workplace, the modifications and arrangements that have been put into place to ensure that they remain effective, and responding by reviewing the risk assessment to any changes in government guidance or to any changes in the specific circumstances of your workplace, such as a case of confirmed coronavirus or an outbreak. So the essentials of any risk assessment are that you must identify all of the hazards associated with the task or activity. And what we're looking at here is a hazard-specific risk assessment. So we're very much just focused on the situations, the activities, processes, and conditions which could give rise to a risk of transmission. And the three hazards that I would ask you to consider as part of your risk assessment would be, first of all, the airborne or aerosol transmission of the virus. Second of all, surface and physical contact transmission of the virus. And thirdly, the contact with or presence of symptomatic or infected persons within the workplace. So your organisation, having identified those three hazards, should have effective control strategies in place to ensure that the risk of transmission is mitigated accordingly. As part of your risk assessment, as with any risk assessment, you must identify who can be harmed and how they can be harmed, specifically considering those that are identified as clinically vulnerable and extremely clinically vulnerable individuals. We need to reduce risk by implementing controls, and the control strategy from the guidance, from the COVID Secure guidance, will outline on the following slides. We need to document and review the risk assessment. So any risk assessment that we carry out within the workplace should be documented where we employ more than 5 individuals. So if we have 5 or more individuals working for the business, we must document that risk assessment. It should be written down. And we need to review the risk assessment to ensure that it remains effective. Really critical, and I'm fairly sure Ollie will cover some of this as part of the employment session following on from here, but consultation with your employees. Consultation with your employees is required by law on matters of health and safety. But beyond that, really, it's the only way to ensure that you've got everybody's buy-in and will maintain their cooperation and adherence to the rules that you're going to put into place. With coronavirus, it's obviously a very sensitive subject. Some individuals are not convinced that returning to the workplace at the moment is a safe thing to do. So consultation with those employees through the risk assessment process is vital to ensure that they are put at ease and feel comfortable in making that return. So what does COVID Secure look like? So COVID Secure, as per the current government guidance, looks like working from home if you can, carrying out and where required documenting a COVID-19 risk assessment, taking all reasonable steps to maintain a 2-metre distance in the workplace, implementing robust cleaning procedures and having robust hygiene procedures and the facilities to maintain good hand hygiene within the workplace, and managing transmission risk finally, where you cannot achieve people working 2 metres apart and maintaining the full social distance of 2 metres, put in mitigating measures that reduce the risk of transmission, but maintain a minimum of 1 metre. If you can't maintain a minimum of 1 metre, or you are having difficulties maintaining the 2 metres and putting in the mitigating measures, then the guidance requires us to consider whether or not those activities remain essential for us to deliver the objectives of our business. So in terms of enhanced cleaning and hygiene procedures, what do they look like in the workplace? We're really thinking with a focus of, first of all, hand hygiene, ensuring that there are sufficient hand washing facilities or hand sanitizers at entry and exit points and other locations around the facility where contact with surfaces or contact with shared assets or equipment might be likely. We need to ensure that we've increased frequency of cleaning, paying close attention to the high contact objects, door handles, keyboards, handrails. Handrails is an interesting one as a health and safety consultant. Spent a lot of time in previous lives delivering inductions to workers using our site facilities and telling them to hold the handrail when they walk down the stairs to avoid falling down the stairs. A sensible health and safety precaution, but one at the moment that people are reluctant to do for obvious reasons, for the fear of risk of transmission. So ensuring you keep those high contact likelihood points as clean as possible will help you to mitigate the risk. Employers should ensure that adequate facilities are provided and maintained throughout work areas to ensure suitable standards of hygiene can be maintained, which is about provision of additional hand washing sanitizer where practicable, and preventing where you can the sharing of equipment, the use of shared meeting rooms and collaboration spaces, the use of hot desking as an example, or ensure that you've implemented strict cleaning arrangements for in-between contacts where you can't avoid sharing. So there's a lot of discussion recently about the reduction, in inverted commas, of social distancing from 2 meters to 1 meter. Now the government guidance still states that 2 meter social distancing should be maintained where possible. And as an employer, your duty is to reduce the risk as far as you reasonably practicably can. Now, all the guidance that we're reading at the moment tells us that that risk, where somebody needs to be in a workplace, is best and most effectively managed by maintaining the 2 meter distance. The reduction, so to speak, to 1 meter of social distancing for in workplaces is only to be applied where the 2 meters is not reasonably practicable, and also with the implementation of additional mitigating measures. We need to be looking at the redesign of our workplaces and the working procedures, rearranging workstations to keep people 2 meters apart, marking areas using floor paint, tape, etc., to help people keep that 2 meter distance. 2 meters is a lot further than you think it is, or certainly a lot further than I think it is. Just walking around a building yesterday, and there were no indications of how far 2 meters was. And I completely lost track with all the signs telling me to stay 2 meters apart. How far is 2 meters? So regular reminders and measured distances is useful. Looking at reducing the occupancy on your site at any one particular time will help maintain the social distancing. So changing shift patterns, staggering start, finish, break times where possible. Temporary pedestrian walkways or one-way systems is important. So having a good management of your people flow around your building or your facility will stop inadvertent face-to-face contacts and excessive bumping into each other in the corridors, working in small stairwells and staircases. The more we can keep people apart, the more we're going to be mitigating the risk. Looking at marking around communal assets, additional access and egress arrangements might be appropriate, implementation of queuing systems, dedicated entrances and exits for certain teams. And as mentioned, where you can't keep to 2 meters apart, manage the transmission risk and maintain at least 1 meter. So here we may be thinking of mitigation measures like screens or barriers. We may be looking at minimizing face-to-face contact, so having a preference for side-to-side or back-to-back working, not face-to-face in some sectors, reducing the occupancy of meeting rooms and shared spaces, ensuring that they are locked down effectively to a maximum safe number of occupants. And where you do need to expose people to each other, because there is no reasonably practicable means of doing otherwise, reducing the time that they spend in that position, and also reducing the amount of people that come into contact with each other in that context. So ensuring you use fixed teams or partnering to minimize the potential spread of the virus through your organisation. In terms of some of the consequences and additional health and safety considerations, these are really, really important. Right at the very beginning of the full lockdown, just after the 26th of March, I was lucky enough to take a trip to my local supermarkets for some shopping, and was very impressed with their social distancing measures that they had put into place, including their queuing area outside of the supermarket. The one small issue was the fact that in standing in that queue, I saw around about 4 or 5 people in the queuing area almost get reversed into by cars leaving the car park. So we put in some good measures there at that supermarket for protection against coronavirus, but we'd forgotten the other key health and safety aspects. Introduced unnecessary risk of being run over by not providing a safe queuing area with barriers and closing aspects of the car park that could potentially be compromised. But there are other things that you need to consider. If you're operating at the moment with a reduced number of employees on site or plan to continue doing so for a period, have you got sufficient individuals in place to manage first aid, fire and emergency procedures, or do these arrangements need to be reviewed? Have you created, through your COVID-19 controls, lone working situations that now need to be risk assessed and managed? Is there adequate supervision of high-risk tasks and activities to ensure that they're still being carried out safely? Has the shutdown itself impacted your completion of the normal statutory tests, maintenance and inspections associated with work equipment and the facility that you operate in? Are your fire systems, water systems, lifting equipment and pressure systems up to date with compulsory maintenance schedules and statutory inspections? And has any damaged or defective equipment or unsafe property plant arisen as a result of the shutdown? And does this now need to be reassessed before put back into use? And finally, training certifications may have expired during the lockdown. It's been difficult to get certain qualifications refreshed. Classroom training has been difficult to get hold of. You need to check with certified bodies, such as those providing certification for workers using powered access equipment, those erecting scaffolds, those carrying out first aid treatment. Check with the issuers of those certifications and qualifications to see what measures they've put into place to ensure continuity and ongoing validity of those qualifications. Have your COVID controls created risks? So have you done a Tesco's and put your queuing area outside your building right through the middle of the car park, introducing unnecessary risk to people using it? Have you thought about the impact of the measures on general safety awareness, the COVID blindness, as I'm going to call it? Individuals who are ensuring they keep their hands clean at all times, ensuring they keep 2 metre distance, making sure they give people a wide berth on walkways, but not thinking about, when giving them a wide berth on the walkway, that they're now walking in the forklift truck operating area. So there will be situations in which employees who focused on COVID control do put themselves at unnecessary risk, and you need, as employers, to be looking at these as well. Induction of those returning to work is important, not just on the COVID controls, but also if they've been out of the workplace for a period of time, the normal health and safety arrangements that you have in place, just to ensure that they are fully refreshed upon their return. So that concludes the health and safety section. So I'm going to take my slide share down and hand over to Ollie to pick up on employment.
Thank you, Chris. Appreciate that. Yes, I'm going to pick up where Chris left off, but looking more from the employment law perspective. So in terms of my agenda, let me just flip through Chris's slides here, get to the right part. I'm going to be having a quick look at some of the issues that arise from making the workplace changes you need to create a COVID-19 secure workplace. What issues will arise from an employment law perspective? I'm just going to touch briefly upon self-isolation and quarantine, just because it's got quite confusing, and getting a clear message across the staff is really important. More importantly, I'm going to touch upon enforcing staff compliance. If we're going to create this COVID-19 secure workplace, then we really have to ensure that staff are aware of what our rules are and that they stick to those rules and they know what the consequences are if they breach those rules. And then I'll turn on to look at another sort of key area of risk that we envisage as people return to work now, which is people refusing to return to work because of health and safety concerns and the protection they potentially have. And then, as Chris mentioned, we'll move on to Q&A. So firstly, Chris mentioned before that when you're creating a secure, COVID secure workplace, you might need to make some changes to the working environment or the hours of work, or the duties that people carry out, or the way in which they carry out those duties. And those changes may or may not be changes that are sort of governed by the employment contract. So when you are making these changes, you need to review what those changes are, and then decide whether or not those changes result in a change to the terms and conditions of any of your employees under their employment contract, such as their hours of work. So we talked about staggered start and finish times. If you're changing someone's start and finish time, that could be a change in an employment condition. Are we changing their place of work? Are we changing their duties? If they are governed by the employment contract, then you need to check that your employment contract allows you to make those changes. So review what flexibility clauses you have under your employment contract. But, and this is the big but, just because you have a clause that might allow you to change the hours of work or to change the place of work of a particular individual, those flexibility clauses are interpreted quite narrowly by the courts and are also limited by implied terms. So in terms of the implied terms, any changes you impose must be carried out in good faith, with a good reason, and with reasonable notice. But also, when they're interpreting how a flexibility clause is going to work, the courts will really be quite narrow. So by way of example, I've put this case on here. This particular case involved a divisional contract surveyor, and the employer wants to change him into a role carrying out the role of a quantity surveyor. And it was held that the job title didn't give sufficient flexibility to change it into a quantity surveyor, and it was a breach of contract. Another example, one we see quite often, a company will quite often reserve the right in their employment contract to change your days or hours of work or your shift pattern. And that might be highly relevant as we look to stagger people's start and finish times. The problem with this is that clause may not be enforceable if that change also has an impact on that individual's pay. And so we need to have a look at what the impact of the change is on individuals and decide whether or not that is properly and unequivocally covered by the employment contract. If it is, we can rely on the contractual terms to change it. If it's not, then we're going to need to seek agreement. Unilaterally imposing changes on employees could result in constructive unfair dismissal claims or possibly discrimination claims. So consultation with your staff will also be key in making sure that they buy into the changes that you need to put in place to ensure you've got this secure workplace. You know, and in that respect, you know, sort of our experience so far is many employees are more than happy to cooperate with the employer where they reasonably can do. So consultation will be key to getting that buy-in that Chris talked about before. The next part I want to just touch upon is self-isolation, and I've put this picture of a confused man there because if you look at self-isolation and when you have to self-isolate and when self-isolation ends, whether it's because you're symptomatic or you're in a household because of track and trace or because you're coming back from abroad from a country that's not exempt, it's sometimes unclear as to how long you've got to self-isolate for, when that period comes to an end, or when you can legitimately return to some kind of normality. And the point I'm trying to make really is if we are confused as to what self-isolation, you know, when someone should self-isolate, then the chances are your staff are also going to be confused. And this is really important because if you're trying to create a COVID secure workplace, then your staff need to know when they mustn't come into work. They need to know when they've got to self-isolate, when they can come back to work after self-isolation, what happens if they live in a household with someone else who is symptomatic, etc., etc. If they don't know, then you're increasing the risk of employees coming into work when they shouldn't and increasing the risk of transmission. So communication around this is really important. And I've put it in today's slide primarily because a couple of weeks ago, I was working with a client who operates a number of children nurseries across the county. They wanted to give this guidance to their staff as to when to self-isolate and when to go and get a test. And when I was looking at what they'd put in their guidance and compared it to the government guidance, there's a massive mismatch, which I had to tidy up for them. So it just goes to show that we might not know what those rules are. Let's get familiar with the rules and let's share those rules with our employees. So the next few slides, I'm not going to go through these slides. They are for your benefit, really, to go away and digest. It's a summary of the self-isolation rules when you're symptomatic, when you live in a household with someone who is symptomatic, when you need to end self-isolation or when you can legitimately end self-isolation, the self-isolation arising from test and trace. There is some government guidance on from the NHS in terms of test and trace and self-isolation. Importantly, there is guidance for employers ensuring that the workplace is safe as possible and encouraging workers to heed any notifications of self-isolation. So it comes back to that point I'm making. You've got to tell your staff when they need to self-isolate. Don't assume they know. There's a little slide there on self-isolation and returning to the UK from abroad. In this respect, you'll also have to have a think about your policy and rules around people taking holidays abroad this next 6 months. What if they want to go to a country which is currently not exempt, which means they've got to quarantine for 14 days upon return? What's your position going to be in relation to that? So we need to be communicating again with staff about what our rules, procedures and requirements are in relation to these issues. But just in terms of what employees are entitled to if they do self-isolate, the statutory sick pay regulations were amended probably, I think, in early March to enable those that are self-isolating because they're symptomatic or they live in a household with someone who is symptomatic to be able to claim statutory sick pay from day one. They've now extended those regulations to capture people who are told to self-isolate because of the test and trace system. So anyone who is self-isolating because of test and trace is deemed incapable of work and entitled to statutory sick pay. So essentially anyone that is self-isolating is entitled to statutory sick pay. The question we often get asked is, do we have to pay contractual or company sick pay? And our answer to that is probably not. It depends on what your employment contract says in relation to the sick pay entitlement. But the general legal view is that the definition of incapability under your employment contract is more likely than not going to say that you're incapable of working due to incapacity or injury. And if you're simply self-isolating, and that doesn't necessarily fit within that definition, so you don't have to pay contractual sick pay. However, you might choose to do so as a business, particularly if you want to encourage employees not to come in when they are self-isolating, not to come into work when they should be self-isolating. So there's a judgment to be made there by the business as to what, again, is your policy in relation to people who are self-isolating. What will you pay them? SSP only, contractual sick pay, or will you, if you're going to go on SSP only, and some employees are worried about the financial impact that that might have on them, could you offer them the opportunity to use some accrued holiday leave up as well? So just think about, again, giving your staff a clear understanding of what your expectations are. So it boils down to workplace communication, and if you haven't done so already, these are sort of the key areas that I think you need to be talking to your staff about. Firstly, you need to explain the mandatory self-isolation rules. They need to be crystal clear as to when they need to self-isolate. Secondly, you need to explain what your position is in relation to sick pay. Thirdly, you need to explain what the individual's responsibilities are outside of the workplace in relation to social distancing. And I know that sounds a bit perverse that we're telling them what to do outside of the workplace, but again, we are trying to minimize the risk of transmission in the workplace. To do that, we need our staff to comply with the government guidance on social distancing outside of work. We need to explain the new rules and requirements that we have put in place in the workplace, which Chris talked about. We need to induct the staff on what the new requirements are. We need to also explain to our employees what our position is in relation to holidays abroad and any self-isolation issues that occur upon returning from holiday. And more importantly, because this is about compliance with the rules and maintaining a safe place of work, we need to be crystal clear with our staff what the consequences will be if they fail to adhere to the policies, the rules and procedures that we have put in place, including their requirement to comply with government guidance outside of the workplace. And importantly, we need to be making it clear that disciplinary action might be a consequence with potential dismissal, because this is a potentially serious health issue. And if people are reckless in their conduct outside of work, increasing the risk to their fellow colleagues in the workplace, then that should be treated with the utmost severity. So I just wanted to this is a sort of a very brief case study that came across my desk last week, actually. Employee, 4 years service, so they've got the protection from unfair dismissal. They call in sick on Friday the 17th of July at 8 AM, saying they've got a really bad hay fever that day, so bad that they're unable to work. So they report in sick. On Monday the 20th of July, the employee calls again and says he thinks he's got COVID-19 and he's going to go for a test. So he won't be in and might not be in for the rest of the week. On that same day, the employer receives reports from fellow colleagues with evidence from Facebook, don't we just love social media and Facebook, that the employee attended a party on the Friday evening with more than 2 households present. So the employer's initial concerns are, firstly, really ill on the Friday. It was lingering because he said he was unwell to come into work, but ended up going to a party in the evening. But secondly, and probably as important, is the concern that he has breached the national lockdown rules or social distancing rules in relation to attending this party, thereby increasing the risk of exposure to COVID-19, and so potentially reckless in terms of his own health and safety and that of his colleagues if he was to come back into work. So if you are faced with a scenario like that, then the key is to go through a fair disciplinary investigation and process. So conduct, in terms of, a fair dismissal, conduct is a fair reason for dismissal, depending on the seriousness of the conduct in question. Tribunals tend to find breaches of health and safety to be at the serious misconduct to gross misconduct level. There is little tolerance given to employees that flout health and safety rules. Once you're aware of what the conduct issue is, you've got to investigate that thoroughly to establish the facts. Once you've established the facts, if there is a case to answer, you invite the individual to disciplinary in writing, outlining the misconduct allegations, the facts that we rely upon, the evidence in support of those allegations, and what warning of what the potential outcome of that disciplinary action may be. We then hold the disciplinary, allowing the employee to be accompanied, and after the disciplinary, we'll make a decision in writing with the right to appeal. That's a very brief summary of what a fair dismissal process looks like. In the particular case study I gave to you, it transpired that the party that this individual went to consisted of, I think, 6 people, all outside and social distancing allegedly, and therefore we couldn't actually prove that it was in breach of the social distancing rules of the government. So the individual wasn't dismissed, but they were sort of had some disciplinary action taken in relation to the party it attended to that night having not come into work, but they used it as an opportunity to remind him of the importance of complying with social distancing rules outside of the workplace as well as inside. But you can see more of these issues occurring over the course of the next 3 or 4 months, and particularly with East Lancashire, we've got high COVID-19 rates. There might be an increased measures to lock down the Blackburn and possibly Pendle. And if there are, then again, compliance with the restrictions that are put in place is important. The next challenges I think employers are going to face over the coming months are getting people back to work. And the likely candidates that are going to refuse to return to work are those that fear for their health and safety and welfare because they are deemed to be a clinically extremely vulnerable person. However, note that they are no longer being advised to shield after the 1st of August. or they are a clinically vulnerable member of staff, or they are staff living with a one of those two categories, or they have mental health issues or anxiety disorders, which is causing them to have a real fear of coming back to work. And then on top of that, you're going to have other people that believe that the health and safety measures that you have put in place as an organisation aren't sufficient to protect them from the risk. So in terms of those categories of people that may refuse to come back to work, the potential risk for you as an employer, if you deal with it incorrectly, certainly disability discrimination. So if you've got people who are the clinically extremely vulnerable people or the clinically vulnerable people, it's more likely than not that they will have some health conditions that may mean they have a disability. But in addition to disability, there might be age discrimination issues because older people have been told to shield up till now. And then given the impact that COVID-19 seems to be having on the BAME community, then there is also a potential of race discrimination. So we need to be really careful with how we deal with it. On top of that, if we dismiss someone because they're raising health and safety concerns, or we subject them to some kind of detriment, such as not paying them or imposing a warning on them, then there are potential risks that might follow. And I just want to talk through the health and safety dismissal aspect a little bit further. So under the Employment Rights Act, we have two sections. Section 44, which talks about not subjecting an employee to a detriment, and Section 100, which talks about not automatically unfairly dismissing someone. And both these sections relate to health and safety. They are pretty much exactly the same wording, but I say one's for detriment and one's for dismissal. And essentially what the clauses in the legislation say is that the individual has the right not to be subject to a detriment or dismissal if the reason is because, and these are the key highlights, in circumstances of danger, which the employee reasonably believes are serious and imminent, and which he could not reasonably be expected to avert, the employee leaves or proposes to leave or refuses to return to their workplace or any dangerous part of his workplace, or they took appropriate steps to protect themselves and other people from that danger. Now, the tribunal will consider all the circumstances, including the employee's knowledge and the facilities and the advice available to them. And that comes back to a point that Chris mentioned earlier around health and safety consultation with employees. If you want, as an employer, to be in the strongest possible position to minimize an employee having a successful claim under either of these sections, then consultation with your employees around the health and safety measures that you've put in place to ensure the workplace is COVID-19 secure is critical. Not only is it a legal obligation, but what it does is it means that you will have consulted with your employees or elected employees, and you will have got their ideas, their suggestions, their views on how we make that place safe, a safe place of work. And having got their ideas and suggestions, it's more likely than not that if they believe those to be reasonable measures, then everyone else, all the other staff, should believe them to be reasonable measures as well. So the consultation is a really key part. If I was to defend a claim like this, I'd want to see that an employer has consulted with its staff on the measures it's put in place. But just looking at the section there, and COVID-19 in particular, there is no doubt that COVID-19 places people in circumstances of danger. We're quite confident that tribunals will interpret that provision quite widely. There is also no doubt that the risk of COVID-19 transmission is serious and it is also imminent. And therefore it follows that an employee will probably reasonably believe it is serious and imminent. It's going to be very difficult to challenge that belief. So the only real angle where we're going to be able to challenge a health and safety dismissal and someone who's bringing a claim under this section is around this, which he could not reasonably be expected to avert. So in that respect, I'll come on to that in a moment actually and just explain a little bit more about not being reasonably expected to avert. But in terms of an example, if you took a firefighter and they are being asked by their station officer to go into a burning building and to rescue a person. They have been trained to deal with fires, they've been trained to rescue people, they've been trained to take all the appropriate measures to protect themselves, they've got all the necessary PPE equipment they need to do that job. There is no reason or legitimate reason for that firefighter to refuse to go in and do as instructed. And if he did, I believe you'd have grounds to dismiss. On the other hand, if you're saying to the station officer, saying to the firefighter, that building's just about to collapse, can you go in and rescue this person? Then that individual, that firefighter may well say, well, I'm sorry, I'm not prepared to do that because I'm not trained and I haven't had any guidance on how to avert a collapsing building. So that's a distinguishment, as that you can see how finely balanced that issue can be, and it's about whether or not the employee was in a position to reasonably avert that danger. Other key points from that legislation. The legislation extends to other persons. So if it's a danger that is to that individual or the workers or other persons, then they are allowed to rely upon that act. And the case that I cite there related to a restaurant which extended protection to members of the public. So an employee was allowed to refuse to go into the workplace and do his task because he felt that the activities that were taking place in that restaurant posed a risk to members of the public. Danger has a wide meaning. It doesn't need to relate to physical workplace either, and it can extend to workplace bullying and intimidation. So if an employee was saying that I am not prepared to come back to work because my health, safety and welfare is seriously at risk because I'm sort of being bullied significantly by X, Y and Z, then they could legitimately rely on this section. It's the employee's belief that counts. It's not our opinion whether their belief is reasonable or not, it's their opinion. And then I come back to this point about can they reasonably avert the danger? And I think the example of the firefighter adequately explains the difference between being trained and given all the equipment to avert the danger and not being trained and having the equipment to avert the danger. So if you are faced with a refusal to return to work, I think key guidance from me is do not launch into disciplinary action immediately, threatening disciplinary action for being AWOL, or try any attendance management process. Take advice first. This is a high risk area because of the multiple different kind of claims that individuals could pursue. The key will be to show that the employee's actions are unreasonable and inappropriate, and that their response is disproportionate in the particular circumstances. We will require evidence that the health and safety systems and procedures that you've put in place adequately deal with the COVID-19 risk, that you've consulted with the Health and Safety Committee or elected employees, and all areas have been covered. That bespoke risk assessments are carried out for those that are clinically vulnerable. That adjustments have been made in line with government guidance and health and safety advice. That you've sought to work through the individual's particular concerns about the workplace before you've decided to take any formal action. And you've tried to resolve their concerns by putting in place adequate measures to overcome them. And then ultimately, if we still haven't been able to get to a point of resolution and getting the employee to come back to work or to undertake certain activities, then we might instigate appropriate disciplinary action, but we must follow a fair process. And the final point I put on that slide there is extra protection for pregnant women. And therefore, again, if you are faced with a pregnant lady saying that they're not prepared to come back to work, please do take advice because you've got to tread very carefully. If someone is saying that they are not prepared to come back to work because they are concerned about their health, safety and welfare, but let's say they are clinically vulnerable and shielding, there are potentially alternatives to dismissing them for health and safety reasons. So if you took action against that individual because of a protected health and safety refusal, that approach is possibly unlawful. If you can't justify that dismissal, it's possibly unlawful. But you might be able to justify a dismissal if you take a process along a capability route. So let's say we anticipate that COVID-19 is going to be with us until Christmas, January, February, March. And a clinical vulnerable person says, I'm not prepared to come back to work because of my health condition, because COVID-19, could be seriously dangerous for me if I came back to work. In those circumstances, rather than looking at it as a health and safety refusal to come back to work, I would treat it as a capability issue, get medical evidence on that issue, and if the medical evidence says, yes, that individual is right, it's too high risk for them, then they are not capable of working in the new environment that we have. And therefore, we would have fair reasons to potentially bring that employee's employment to end on grounds of capability. So there are solutions there. Don't always have to go down the the other route of dismissing someone because they're refusing on health and safety grounds. What about pay for someone who refuses to return to work? So firstly, if an employee wants to be paid, they've got to be ready, willing, and able to work. That's a precondition. If the reason for the individual is that they are not willing or able to work because the workplace is so dangerous, then they are potentially protected under Section 44 or Section 100 of the Employment Rights Act, and we would say they are still entitled to pay. But this comes back to the point that we might have arguments to say, well, can they take reasonable steps to avert the danger? But we'd have to work on the basis that until we resolve those issues, they might still be entitled to full pay. If, however, the reason the individual is refusing to come back to work because they are clinically vulnerable and say they are shielding, then they are not entitled to pay, but will be entitled to sick pay. And the reason being is that the refusal to come to work is not the health and safety measures that the employer has in place, it's their medical condition that is the cause of them not coming back to work. Now, before we took any action in relation to this individual, we'd have to clearly go through a proper process, and we'd also have to rule out the risk of a disability discrimination claim. But I'm hoping that that just explains the difference between when you might have to pay someone and when you might not need to pay someone. Now, of course, if you don't pay someone, if you choose not to pay someone for not coming back to work, then you can take the commercial risk, and it's for the employee to challenge that decision under Section 44 as being subject to a detriment. And as I say, I've just mentioned before, we potentially have the grounds to defend such a claim on the basis that the employee didn't have a reasonable belief that there was a danger, and which was serious and imminent, although I think that was difficult to prove, or that they could have taken reasonable steps to avert the danger. So you will have a choice, but again, I'm just trying to emphasize the importance of taking some advice. Potential solutions to this problem. Well, come back to a common theme really throughout today's session. Communication is key. Communicating with the entirety of your workforce, but also any individual that has particular concerns. Involving employees in the creation of a COVID-19 secure workplace. For those that are uncertain or remain wary, early communication with them is key to try and ease their transition back to the workplace and resolve any immediate concerns they've got. Review your risk assessments for the individual's health condition and identify any additional measures that you need to take to safeguard their health. Try to agree a plan for return to work, including discussing the health and safety system in place, any needs that the employee may have. Review the risk assessment with the individual. Note that clinically extremely vulnerable people should still be kept 2 meters apart from people outside of the household and from their social bubble. So ensuring that they shouldn't breach the 2 meter distancing in any circumstances in the workplace. And about options that you might have for someone who's refusing to come back to work, can they work from home? Coming back to that first point that Chris mentioned, if people can work from home, that should be your first port of call, even now in this current situation. Even now, Boris Johnson is trying to tell everyone to get back to the offices. The reason employers aren't doing that is because they have their health and safety obligations to comply with, and it would be irresponsible to send everyone back to the workplace when people can adequately work from home. Consider redeployment into another role in a safer area of the business. Look at any extra personal protective equipment or measures of adjustments you could make. Consider changing their working hours or place of work by agreement so that they're not exposed to the transmission as much as they would be on their normal working hours or arrangements. Continue with furlough leave, or potentially have a discussion with the employees about other forms of absence. If they're not going to come back to work, rather than disciplining them because they have concerns around their health, safety and welfare, maybe we could agree a combination of unpaid leave and holiday leave. See if you can find a solution. If you can find a solution which they're happy with, then the chance of a claim is much reduced. Finally, final slide. Appreciate we've run over slightly. Things that you will need to do from a HR employment law perspective: review your sickness, absence and pay policy. Make sure that you're clear with your employees on what your position is in relation to self-isolation. Review your health and safety practices. Review your disciplinary policy and procedure. Make sure that your staff are clearly aware that disciplinary action may well follow if they fail to adhere to our rules inside and outside of work. I've mentioned here reminding staff about bullying and harassment and equal opportunities in the workplace. There is potential risk of, for example, the BAME community being subject to harassment because of perception that they are causing COVID-19 issues. We've already seen it in some of the local press. If you ever read the comments on some of the articles in the local press, it's diabolical. But if that's going into the workplace, then some of your staff might be at risk of being subject to discrimination. So just reiterate the rules around that. There'll be increased requests for flexible working, so dust off your policy and make sure you're up to speed with it. You'll need to review your home working policy and make sure it's fit for purpose. Review your annual leave policy for this year. The law did change to allow any employees that have not been able to take their holiday leave this holiday year because of COVID-19 to be able to carry that holiday leave over into the next 2 years. So just consider how you're going to manage that. And then a final thing, there is no doubt with the pressure on people in terms of the worry around COVID-19, the financial impact of redundancies, within their families or reduction in pay, etc. The mental well-being of your staff is without doubt going to be affected. So have a look at what your mental well-being sort of plan is, review it and see if you can improve it and put more measures in place to support your staff. So that's it from me. I think, any questions, Simon? I don't know if you want to compare.
Yeah, so if anyone's got any questions, the best thing to do is, it's quite a small group, so feel free to unmute your microphone and just put your questions directly to Chris or Ollie. I'll kick off if I may. I mentioned at the top that I've read some guidance this morning that business events are going to be allowed from the 1st of October. Chris, have you got any view on what they'll look like and sort of what the return to networking events and seminars will look like from October onwards?
Yeah, thanks, Simon. I think we've looked at it certainly for ourselves from a classroom-based training perspective, and I think it's going to be very much like the COVID Secure Workplace guidance. I imagine there will be specific guidance for these types of events, and actually whether or not these events will be better held in that in a COVID secure forum, or actually in a forum such as this will be will await that guidance to see. I think the key thing is, as with all of the guidance, there is going to be a requirement on anybody hosting such an event to maintain social distancing and to implement the hygiene controls as is consistent in the workplace guidance. So it is at this point unlikely that it will be significantly different unless there is an overall change in the approach by the time that that guidance and that sort of rule comes into effect. It could be that due to the risk of transmission at that point in time, the situation may be relaxed slightly in terms of the distancing, etc. But I think Zoom conferencing is here to stay for the foreseeable, and any such events will probably be limited, certainly in terms of capacity.
Okay, great, thanks.
Simon?
Yeah, go on, Reid.
Yeah, obviously as the co-chair of the CDA, our meetings held monthly, as you well know, and even though the government are saying we can meet again in October, given that, small organisation, not for profit, my attitude is the risk is far too high for a potential COVID spread and then a health and safety issue and risk. And I don't want anyone, even a member, to claim against an organisation. So is it worth it?
I'll pick that up, Chris. It's a good question, and I think by way of example, I think Napthens, although we've not made any firm policy on this, it is possible that we might not attend any sort of business events until the new year, and maybe longer. Ultimately, the employer's responsibility or the organisation's responsibility to protect the people that are within its care, the staff, any visitors that you might have. And it's you that will pick up that liability through your public or employer liability insurance. I suspect ultimately, though, it's all right an employer or an organisation saying we're going to go ahead with these events, but we might end up in circumstances where employees say, well, that's all well and good, but I'm not going. So employees might have one idea and employees might have another idea, in which case we come back to that issue of people refusing to undertake certain activities, such as business development or business events or business meetings, because they think the risk to them is too great. And they've got a very easy argument to say, well, if that activity can be done by Zoom, why put me at risk?
Why not? One more question, Ollie, if I could, specifically for you. Some of the members know that, for example, my wife is disabled. She's on the very at-risk register. And I was sort of applying this to myself in case somebody else threw this into the pot, that I'm not going to return to work, because certainly my wife is worried that when I go into work, I increase her risk. I don't believe I do, but because there's an anxiety issue there as part of the disability, it increases problems for me. So what I personally be doing, I think it was reasonable, obviously as a director, I work at home the majority of the time. I go in for short meetings, limit my exposure, and reduce my stress at home from hassle. Yeah. And I think that's the other things. And a second question is, we've had an employee gone on holiday to Greece. She's gone back because of families have died. She presumably will be self-isolating when she comes back. Because it was done before this webinar and I didn't realise the issues, am I supposed to tell her she'll presumably still can't work, and does she get paid? Yeah, because it's self-imposed.
Yeah, I'll take the second question first. I'm not too sure, but I think Greece might now be one of the exempt countries from the self-isolation requirement, but check it. There is a list of exempt countries. I know because my son's booking a holiday to go there in a couple of weeks' time, so that's the first question I asked him. So I'm pretty sure it's exempt, but just double check it. If it's not exempt, then they have to self-isolate for 14 days. And I think at best they will be tasked to SSP only, but that also doesn't feel quite right when it's potentially being self-imposed because they didn't have to go on holiday. I think you'd have a conversation. The last thing you can do, if it's one of the countries that isn't exempt and they have to self-isolate, then they mustn't come back to work, and you've got to find a solution to overcome that. So if they can work from home, great. Make sure that can happen. If they can't work from home, and then it may well be a combination. If sick pay, if they're not entitled to sick pay, it might be a combination of unpaid leave or further annual leave, which they hadn't budgeted for. But we are where we are. Hence the reason why I'm telling employers now to get their message out to employees about our expectations as employees when they go abroad, and the implications. The other question you asked about, your wife being clinically vulnerable, and taking the example of you as the partner and not wanting to go to work because of the perceived increased risk it might have to her. What options does an employer have? What options does an employee have? Well, again, if you can work from home easily, then I don't see any reason why an employer shouldn't accommodate that. And they might not necessarily agree with the fact that you're not coming into work, but given the circumstances you're describing, I think it would be unfair to take you through any kind of disciplinary process to terminate you in circumstances where you could fulfill your duties at home. If you couldn't work from home, and you have to be in the workplace because of the nature of the duties you do, then you wouldn't really have much protection. You're not entitled to self-isolate. The reason for you not wanting to come back to work isn't because of health and safety issues at work, it's because of your wife's condition. So I think in those circumstances, an employer could potentially take disciplinary action for a failure to return to work and dismiss, but only after exploring all alternatives. You know, it seems quite draconian to dismiss someone in those circumstances you described, and an employer would have to show that they really have explored all alternatives and there are no obvious solutions. And again, it's about time frame as well. If we're looking that you're going to come back to work in 3 or 4 weeks' time, then an employer will be expected to make reasonable adjustments for a temporary period. If it's going to be 3, 4, 5 months, then an employer might not be expected to put up with that situation for as long.
Yeah, I suppose it's our chairman is the pushing driver in this, that they want to see us, and you know him, so I'm being careful. About getting back into the office, this perceived business about you can only do the work when you're in the office, and we've shown that in this lockdown that you can work remotely, and I think you're right. The communication and reasonableness, you know, as designers, you can work in isolation, you can communicate, and I think just having limiting people in the office almost to 1 person per room is what we've taken the attitude of, because they may need a piece of equipment, for example, that they don't have at home, and other people like me that aren't trained on it can work away. And I think that's a reasonable adjustment given the circumstances.
Yeah, I think it comes back round to the health and safety responsibility here. The guidance still is, if you can work from home, you should work from home. It's as simple as that. No matter what the employer's preferences might be, in terms of trying to get people back to work and start that team engagement and social interaction again, which I think all of us want, ultimately, we shouldn't be putting people's health at risk. And I think it's background to what Chris Walker was talking about before.
All right, thanks, Reid. When we can, I want to look very closely at your Disneyland map behind you, because I'm fascinated by what looks like an old plan.
That's the original Euro Disneyland one from the first week it opened, and it hides a lot of shit.
I need to study that. I've got 2 questions that will quickly rattle through. I don't know if it's Dana or Dana, but she's having audio problems. So she says, it's just scrolled, disappeared. I can't get my mic to work. Can employers enforce holidays to be taken during furlough? I know you answered that in your first record-breaking webinar back in March, Ollie, but do you want to take that again?
Yeah, I put my neck out on a limb at that record-breaking seminar sort of a few months ago when I said employers could force employees to take annual leave whilst on furlough, because I know there was some legal opinion that differed to that. But I'm pleased to say that both the HMRC and the government have acknowledged that that is permissible. The key, however, is you've got to give twice as much notice as the period of leave you want them to take. So if you want them to take 5 days holiday, you've got to give them 10 days advance notice. If you want them to take 2 weeks, then it's going to be 20 days advance notice. And on that same subject, you can also require employees to serve their notice period whilst on furlough as well, which was again up for legal debate. And again, we sort of stuck a neck out and said you can. And the HMRC have recently confirmed that you can indeed ask people to serve notice whilst on furlough as well.
Thanks, Ollie. And then final question, Nadine, do you want to put your question?
Yeah, I was just wondering, I work at Blackburn College, and Blackburn College obviously have done loads of work, and we have been consulted as staff, and lots of this has been going on, and it's been great, and we're all raring to go back in August. We're still all working from home. I just wondered, where did the students come into this, and how would we police, or would we what they're doing outside of office hours, if you will, because they're coming into our office, if you understand what I mean?
It's a good question. It's probably a little bit outside of my remit, but I think ultimately students at Blackburn College will be permitted as students subject to adhering to certain rules. And I think, again, it's clear that we need to consult with students in terms of what measures and steps need to be taken to ensure their safety as well as the safety of the teaching staff and other workers. And then we need to sort of communicate what those agreed rules are for all students, and be clear that the consequence of breaching those rules, if we become aware of it, may well be a sort of temporary expulsion or permanent expulsion. I'm presuming you can, as colleges, expel students. So,
so it's maybe building it into the induction and that sort of thing when they first come back, and just highlighting risks. Yeah,
absolutely. And sharing that with the parents, because we've got to ask the parents to get that same message across to them, so it's coming from both the college and from the parents, and hopefully the message will sink in. Not always easy with 16 to 18-year-olds, but you can only but try.
Yeah, thank you.
Thank you, Nadine. I think that's it for questions. Dean, you're unmuted. Did you have a quick question?
Yeah, just a quick one. In terms of people getting SSP and coming back to work, do they have to still get a fit to return to work certificate?
In theory, it depends on what the reason is, but I'm assuming you're talking about them having self-isolated, being entitled to SSP, or...
Well, not so much that. I had a case a few months ago when there was a client of mine had a member of staff that was off work having had an operation, and then when furlough started, wanted to come back to work, only then to claim furlough payments, which would have been significantly higher than an SSP.
Yeah.
So I trust that they were just saying what other colleagues were getting the furlough payment as opposed to SSP. Yeah. So we actually advised them to ask for the fit to return note from the doctor, which would then facilitate can they not come back to work. Ultimately, the business was closed and they would have had to furlough her.
Yeah.
But I don't know if that's still a thing that we ask doctors or that ask the individuals to produce a fit to return note.
Yeah, I mean, we get it quite often when employees, are signed off for, let's say, a couple of months, and then a month in, they say, I'm fit to come back, I want to come back early. I think in those circumstances, an employer is perfectly entitled to say, sorry, I've got a fit note that says you're not fit for 2 months. If you want to come back early, we need something in writing from your GP to say you're now fit to return. If, however, their fit note expires after 2 months and they say, I'm now fit to return to work, then employer is entitled to take that presentation at work as them saying, I am fit to work now and do my full duties. Obviously, an employer will be well advised to hold a return to work interview and ensure that there's nothing that we need to do to support them now they're back at work. Are there any ongoing issues that we might need to make some adjustments? But I think we can only really request a fit to return to work where they're looking to return earlier than the expiry of their original fit note. So with that particular person on furlough, that was a common issue when the furlough scheme was first put in place. I had quite a lot of employers. Obviously, you don't have to put people on furlough. And a lot of employers basically said, until your current fit note expires, we're not putting you on furlough.
Brilliant. Top man. And well done, Chris, today. Great presentation.
Thanks, Dean. Thank you then to Chris and to Ollie. Thanks to everyone for joining us. We will put the video on YouTube. It will form part of the Ollie McCann's Greatest Hits collection on our YouTube channel.
Coming in at number 10 though.
We'll also circulate the handout for the slides from today in Debbie's post-event email. And don't forget to join us for next week's Chamber Live. 10:30 on Wednesday. Full details at chamberlive.co.uk. Thanks again, Chris and Ollie. Stay safe, everyone.
Take care, everyone.
Thanks all. Take care.